I'd like to welcome everybody to today's webinar on privacy, cutting through the confusion. This webinar is brought to you by Renewed, the open network for specialized subscription membership and event professionals. My name is Kim Matus, Interim Executive Director at Renewed, and with some quick notes before I pass it on to our moderator, John Hitchcock. If you have questions during the session, please submit them in the chat and we'll address them mostly during the second half during our live Q&A. We'll also sort of keep an eye on them as we go throughout. Also, stay tuned for an email later this week with the recording from today that you can share. I also ask if you're not speaking to please mute yourself. So look out for that recording email. If you're on LinkedIn and you want to share some takeaways, please use #Renewed. And lastly, we encourage you to please invite your colleagues who would benefit from joining not only Renewed's free online community to experience content like this, but also in June at our summit just outside of Washington, D.C. We hope to see you all there. So with that, I will turn it over to our moderator, John.
Kim, thanks very much. And gang, welcome to Cutting Through the Confusion. Privacy is something that is a subject that bedevils us all. And with us to unbedevil is Steve Ankrum, a partner at Powley Gibson, a guy I've known for quite some time. Steve and I are both from the Midwest, which makes us nice guys. The trouble is that Steve is from Ohio and I'm from Michigan. And so that niceness only extends as far as football season. When college football begins, we get unnice. But the good news is it's springtime. Not the fall, and this is privacy, not football. So Steve and I are going to be good pals for the next 50 minutes or so, helping you kind of untangle privacy issues. Just a note, too, that Steve is going to answer some of your questions, where he's going to give you a good basic grounding in privacy. But for anyone who's got particular issues on a particular matter, please follow up with Steve privately for a more appropriate kind of client attorney counseling session. Steve will kind of steer away from that as attorneys must. So with that caveat, let's get into the meat of this thing. Welcome, Steve, and let's start off by just with a little bit of an overview. Why are there privacy laws? What's pushed us in this direction in the last couple of years, and who are they there to protect and punish?
Well, the privacy laws, with the rise of technology and just the sheer amount of personal data that is being collected vis-a-vis our online activities, by your phone, by all of your, activities interacting with technology, governments and individuals are starting to be concerned about, the lack of control that individuals have over their own personal information. And so I think the overarching goal of these various privacy laws that we've seen put in place since the enaction of the EU's General Data Privacy Regulation in 2018 is to give individuals and consumers more control and information about what about how their personal data is collected and used. I think these privacy laws serve an important, public policy function. More materially, why we should be concerned, as members of Renewed about privacy options, is that there could be very strict penalties in place for violations of these laws. The GDPR, which I mentioned a moment ago, which protects the private information of European Union citizens, has very strict penalties. You could be fined up to 20 million euros or 4% of your organization's annual revenues as a maximum fine. And the EU, as of January 1 of this year, had, member states had issued, nearly 3.5 billion euros in fines. From a self-interested perspective, if you're an organization that may be covered by these privacy laws, there's an incentive for you to, maintain compliance.
Okay, Steve, that's great, but you just mentioned the GDPR. Those guys are all the way in Brussels and Paris and London. I'm sitting here in Little Compton, Rhode Island. Why do I care about what's happening in Europe?
Yes, well, yeah, we can talk. I mean, the entire privacy landscape is is a patchwork of overlapping laws. Why should a law that protects California citizens apply to my company in Rhode Island, or the GDPR for that matter? The fact of the matter is that the EU's GDPR protects the private information of European Union citizens. So even if you have no European presence in your organization, you're really not doing business. If you collect personal information about EU citizens, or process that information, or share that personal information in any way, you're still covered by the GDPR. I mentioned briefly these state privacy laws. I mean, many people may be familiar with California's Consumer Privacy Act. A number of other states, 5 other states have passed similar comprehensive privacy laws since California passed their Privacy Act. And while all of these laws kind of protect the citizens of those states, if you make sales, if you do business in California, if you make sales to California residents, if you offer goods and services over the internet to citizens of these states, you may be covered by these laws, even if you don't have a presence in these jurisdictions in any way. So these comprehensive privacy laws do have a very broad reach. And sitting in Rhode Island, your organization very well may have to be concerned with the European Union's privacy laws if you interact in any way with the private information of EU citizens.
So not to be too glib, but do they really care about energy intelligence in the US or other renewed members in the US? Or are they really concerned with kind of the Googles and big guys of the digital world? To what extent do we as modestly sized renewed members need to concern ourselves not just with GDPR, but you mentioned the California Consumer Privacy Act. Consumer Privacy Act, I'm a B2B publisher. I don't deal with consumers. Where do we draw lines?
Well, I mean, there's a lot of excellent routes, to address in that. There are a lot of interesting notions to address in that question, John. Just to take the last point first, California Consumer Privacy Act, when it was initially enacted, had an exemption for business to business. If you process personal information as part of a B2B business transaction, you were exempt from the provisions of the California Consumer Privacy Act. However, the California Consumer Privacy Act was amended, and the amendments just went into effect in January of this year, and that eliminated the exemption for B2B business activity. So if you collect personal information as part of your business to business transactions, and that can be any identifying information, any information that can potentially identify an individual: name, mailing address, email address, and so forth, then you may be covered by the you may be covered. You may be a covered business under the California Consumer Privacy Act. And in terms of the GDPR, and the first part of your question, certainly many, like the biggest early fines, the really big fines that the EU has levied against companies have largely been against, massive tech companies such as, Meta, which owns Facebook and Instagram, Google, Apple, these companies that are processing the information of millions of people. However, they're not just limited to going after the major tech companies. A very large fine was last year in 2021, 2 years ago, was levied against a Australian supermarket company because for violations relating to failure to disclose enough information about how they were using personal information that they obtained through their rewards program. You go to a supermarket and you swipe your rewards card and you get your 10% off your gallon of milk. Well, the company is gathering information about their consumers and their shopping habits. And even though it wasn't a massive tech company, they still got a substantial fine levied against them in regulatory action. So while I think in the initial years we're going to see a lot of regulatory activity aimed at big tech, because that's who is processing and doing the most with personal data, it is not just limited to big tech companies.
Okay. So just, and they're talking about data related to shopping choices. I suppose credit card information too can end up being stored in ways. I can understand how that would be something people would be very worried about, the onward use of that. But if I'm a publisher and all I'm doing is using emails so that I can service my customers, send them an update on what the content we have on our website, or send them a PDF of the latest issue of our publication, I'm only keeping email addresses. Is that really privacy? I mean, to what extent do I have to watch out for that kind of violations because of that sort of personal information?
Well, I mean, there are a lot of steps to evaluate whether you're a covered business under the various laws that we will be talking about today, and what your privacy obligations are to the consumer and how you can handle that information. But email addresses, mailing addresses, the names of an individual, these are common things that, common pieces of information that publishers get from their subscribers and their clients. And this is expressly defined as personal information under the California Consumer Privacy Act. For instance, the definition of personal information under these comprehensive privacy laws are generally very broad. It's any information that identifies, that relates to, that describes, or can be reasonably connected to an individual. So yeah, things as simple as an email address absolutely, fall under that umbrella of personal information.
Okay, so it doesn't have to be the geolocation of my shopping trip to Macy's in New York from Rhode Island. Even my email address has to be considered that way.
It can cover everything from an internet username to biometric data, such as your fingerprints. I think it goes without saying that the level of protection, there's varied levels of protection and obligations you have if you're collecting, biometric data and people's fingerprints and very sensitive information like that. But things as simple as your username, your email address, your mailing address, these things are all considered personal information under these various laws.
Okay, what about, this is maybe a bit geeky, but what about user IDs and IP addresses that my laptop is associated with as I communicate out as a client with another publisher, for instance? At Energy Intelligence, we don't necessarily keep that stuff. It's just part of the way the world works these days, right? That we get an IP address and user IDs connected, identifying a particular device that our clients have used to access our website. Does that constitute also private information, or is that someone else? Is that our problem as private information, or is that the internet service provider's issue?
If you are collect IP address information can be considered personal information in a lot of circumstances. And, that can be a real challenge for any organization that has an online presence because IP addresses are, how the internet works. Like, there's no way to access, a website without sharing some sort of, without sharing the IP address between the computers, because that's, how the nature of the internet and how internet communication works. But if you are logging and storing IP address information, that potentially could identify and relate to somebody. I mean, there's ability to geolocate using an IP address to pinpoint it to a geographic region. And that could reasonably be associated or identified a consumer or a household. So even things as simple, a lot of the basic backbone of any online communication, website communication, is going to implicate privacy issues. And this is without even, and this is not necessary, it's even doubly true if your organization is, tracking users to your website via cookies. If you're using that information, sharing it with advertisers to give targeted ads to your audience. All of this, that entire process involves, the sharing and transferring and processing personal data. The only, one way to avoid this is to depersonalize the data, aggregated data that, about maybe, consumer uses that has any information that, could relate to or identify an individual stripped out of it, then, then you're much freer to store and process that information. Okay. But you should definitely be concerned, you should definitely take a look at, even the very basic information that you're collecting and storing, if you are keeping it.
So it sounds like whether we like it or not, we're covered. These laws are going to affect us. Even if we don't think we've got anything that seems very private. I mean, back in the day, I'd collect business cards, and business cards had phone numbers and addresses and whatnot. Nobody bothered me with that. Okay, I get it. It's now digital. Privacy is a concern. Every state in the country, however, probably has a privacy law. And I do business. Energy Intelligence does business. Most renewed businesses do business across many state lines. How can we possibly keep track of this? Are there benchmarks we ought to be using just to kind of make sure that at a minimum we're doing what any state would want? Or how do we cut this in a way that's reasonable?
I mean that is ultimately the question, right? That's what everyone wants to know. And unfortunately, there's not a one size fits all policy. Did I lose?
No, you're here.
Okay, sorry. Something happened to my screen. I lost the screen, but that's fine as long as I'm still here. So there's really no one size fits all solution. Some large tech companies like Apple have kind of taken a simplified approach where they're going to take the highest measures, privacy measures, the strictest privacy measures, and just apply it across the board, regardless of what law or jurisdiction applies to. And for a large organization dealing with many different jurisdictions, that may be the ideal solution. For a smaller organization where you're not quite sure what your privacy obligations are, the first step you should do is do an information audit. Figure out, take a look at your business and determine what information you're collecting, if you are collecting any personal information, how you're collecting it, for what purpose you're collecting it, what you do with it, how it's stored, where is it stored, and start to put together, an outline of the information that you're actually utilizing. Once you've done that, you can start to determine whether your organization is covered under any of the state privacy laws. The GDPR applies quite broadly if you're processing the data of European Union citizens. The California Consumer Privacy Act and the various state laws that have followed in the wake of California that are largely modeled after it have threshold requirements. So for instance, many of the provisions of California Consumer Privacy Act do not apply to organizations unless they have over $25 million in annual revenues or process the information of at least 10,000 California residents a year, or receive 50% of their annual revenues from the sale or processing of personal data. So a lot of renewed members may not be covered under the California Consumer Privacy Act because they don't have that big of a reach into California. They don't have that level of annual revenues, and their business is not primarily about processing personal data. However, you can still be obligated under the under these state privacy law acts if you don't meet the threshold, if you are a vendor, a contractor, or a service provider to a covered business. And as part of your contracting or service providing duties, there is sharing of consumer personal information between you and the other organization. The law requires covered businesses that use vendors to contractually through contract, through a service agreement, the vendor has to agree to abide by certain principles.
Can you give us an example of what a vendor relationship would be, one firm to another?
Well, certainly. I mean, I had a client contact me as part of and without getting too much detail, as part of the services they provided, as part of the consulting services they provided, they worked with a much larger company that was covered under California law. And unfortunately, for that particular example that's coming to mind, I can't get into too much detail without revealing client confidentiality. Unfortunately, I don't have a great example off the top of my head. But you may, if your organization is in any sort of service provider or contractual relationship with a company, you may this year have received a service contract that was much more substantial than you're usually received, because new laws went into effect this year that require covered businesses to ensure that if they're sharing any private information with with any vendors or service providers that may not be covered by California law, that they have to ensure via contract that the service provider is maintaining those obligations.
Okay, so Steve, we've spent a lot of time referring to GDPR and a lot of time talking California. Is it safe to say that those are the gold standards, so to speak, as Anne Mullaney asks, if we're competent enough to be good and having met the requirements under GDPR and California, are we pretty much safe, or are there other better standards to hold ourselves to?
At the moment, I mean, there are slight differences between the various state laws that can make a difference depending on your business. However, broadly speaking, at this time, I would say California is kind of the gold standard for U.S. state privacy laws. All of the laws that have passed since then, whether it's Utah, Colorado, Virginia, Iowa, have really been modeled after the California law. And while there are some different provisions, generally, you follow the precepts of the California law, you'll be following the precepts of the Colorado laws as well, and the GDPR. But that may not be the case forever. I think I mentioned earlier there are at least 19 states that have various privacy laws at some point in the making their way through the legislative process. And I anticipate that many of these will become law in the next few years. And some of them are more stringent than California's in substantial degree. For instance, one of the privacy bills there's several in New York that are making its way through the process. One of which, puts obligations on organizations that are stricter than California's. For instance, the California Consumer Privacy Act requires businesses to allow consumers to opt out of the use of certain personal information for certain uses. The proposed New York law places an affirmative opt-in requirement. So it takes some of the principles of California law and ups it a little bit. And I would not be surprised if we see additional, more stringent laws be passed over the next few years.
Okay. Thank you. That scares me, our audience. Is there any hope that a countrywide or US-wide standard would be put into place, something passed by Congress?
That would really clarify. I feel like that would clarify a lot of things. I think that would be good for privacy advocates. It would be good for organizations who are covered by privacy laws to have a single comprehensive standard rather than this odd patchwork where it's uncertain what jurisdiction I'm obligated to. But unfortunately, while various laws, overarching federal privacy laws have been introduced in Congress, it doesn't look like any of are going to pass like this year, for instance. So in the near future, it does not look like there's going to be an overall general federal comprehensive privacy act passed. That being said, there are federal laws that cover privacy in certain sectors. So most renewed members are not in the health insurance health providing business, but many people are familiar with the Health Insurance Portability and Protection Act, or HIPAA, which has strict privacy obligations it imposes on organizations that collect and process sensitive health information. There's a federal law that was passed in 2000 that protects the privacy interests of minors under the age of 13 online. So there are certain federal laws that affect certain segments, but the prospects at the moment don't look great for overarching federal law that covers the comprehensive privacy sphere that we've seen the states step up to. So for the time being, given our federalist system here in the United States, it looks like we're going to have a patchwork of different state laws that, while similar, are annoyingly different in some ways.
Well, okay. So, Steve, we've heard many of us about the need to have a privacy statement or privacy policy that can be posted on our website or within the body of agreements that we have with companies with whom we have service or licensing arrangements. What goes into a privacy policy? If you were to have to list the kind of the important pieces, the basic pieces, what do we have to put into that, and to what extent does that protect us against anything?
Well, both the GDPR and U.S. state privacy law share a general principle of disclosure, transparency, giving the consumer the information of how their data is going to be collected and used. And the privacy policy is, the organization's way of satisfying those obligations. So the point is to, inform the consumer what personal information is being collected about them specifically. Inform them whether, how you're using that personal information, how the information is being used, whether it's, being used internally to, for instance, you may be keeping the personal information about, the name, email address of your subscriber so that you can deliver the publications that they have subscribed to. And that is a lawful purpose under the GDPR, as long as you state so in a policy that is readily accessible, then you've satisfied your obligations, under the law. So that's generally the purpose of a privacy policy, is to serve those principles of transparency and disclosure. This is the personal information we're collecting about you. This is how we collect that personal information, whether it's information you've given to us, whether it's information we've collected through cookies that keep certain information when you visit our website. This is what we do with this information, whether we share it with affiliates, whether we keep it, how long we plan to keep it. That's the general information that you're obligated to disclose, if you're covered under the GDPR or these various state privacy laws.
Good. So we've got our privacy policy up. People are reading it, and despite our best efforts, somehow someone serves us with a complaint.
Yeah.
What do we do?
Well, so there are various procedures under the various laws for consumers to request detailed information, like access to the personal information that was kept, the ability to rectify any errors, under certain circumstances, request deletion of that data. And your obligations to respond to those depends on your organization and the laws that you're covered by. Under the California law, you have 45 days to respond to any consumer request, and that time can be extended. However, you do need to acknowledge receipt within 10 days. Under the GDPR, you generally have a month to respond. Going back to California, the nice thing for organizations covered by the law is that once a consumer makes a request or a complaint about the use of private, we'll go to complaints in a second. Once they make a request for information, they can't make a request for another 12 months. So you won't be inundated with the same individual bugging you over and over, under the exercising their rights under the law.
No harassment. They make a request and that's it for 12 months. That's not bad. Yeah,
no, that's not too bad. But yeah, it depends on the nature of the request and the nature of the complaint. There are also, a nature of the complaint could be you have violated my rights under the California Consumer Privacy Act, for instance, because you are selling my personal information to advertisers and you didn't disclose it. Well, if you, under the US state privacy laws, you do have the ability to cure within 30 days the privacy issue, legitimate privacy issues that are raised to you. And if you do so, then the individual is prohibited from filing a lawsuit against you, because that's the next step. If you do not cure any legitimate defects or legitimate complaints about violations, then your organization could be subject to a lawsuit brought by individuals that are impacted. And the California Consumer Privacy Act provides for what are called statutory damages for each violation. So it's a specific range that is set forth in the statute, and the individual is entitled to damages between that amount. They do not have to show actual harm. All they have to show was that there was a privacy violation. And this can get quite expensive if, because if there is with the amount of data that companies are collecting about individuals, if there's a privacy violation, it usually doesn't impact one person. It impacts 1,000 people or impacts several hundred people. And when you have several hundred lawsuits and those statutory damages for each violation, it can get quite expensive. And so obviously the goal is to avoid that wherever possible. And that starts with doing the audit of the personal information you used earlier, making sure that if you are covered by any of the privacy laws, you're compliant with them, and promptly responding to any complaints. And if the complaints are legitimate and there is a violation, promptly curing any issues to avoid that type of liability.
So promptness is your friend. Who is most likely to be knocking on your door with a complaint? Is it an individual or a group of individuals, or a nasty law firm, or is it more likely to be a state regulator kind of checking in on you because they perhaps just have a list of people that they go through and randomly audit?
Yeah, all three of those are options. You could get individuals making complaints. It's very common. I would imagine we'll see plaintiffs' lawyers gathering classes. We've already seen it, trying to gather classes of aggrieved plaintiffs to, bring together in a class action. And through that collective class action, they can, assert more leverage and more liability over you. And we're also seeing regulators. California Consumer Privacy Act was revised since it was enacted, and those revisions went into place in January of this year. And as part of that, are increased, they've issued, starting in June of last year, increased a number of regulations kind of spelling out exactly where the attorney, additional powers and investigatory powers for the Attorney General to investigate privacy issues. So you potentially could see regulators knocking on your door as well.
Okay. You've mentioned California. I think Colorado is another. Are there others? What other states are kind of hot places for privacy legislation and investigations?
So the states that have passed similar comprehensive privacy laws, similar to California's, since California's are, and if I could do them in the order they were passed, that would be great. But no, I don't remember exactly the order they were passed. But Utah, Colorado, Iowa, Virginia, and Connecticut have all passed similar comprehensive laws. And there are at least 19 states that have laws that are either been introduced or in committee and are working their way through the legislative system. Now, not all of those laws are going to pass, and not in their current form, but it is a guarantee that there will be additional state privacy laws passed over the next few years. And as I mentioned earlier, brief reference to New York and other states are contemplating privacy laws that are more extensive than California's, which right now is sort of the gold standard in U.S. state privacy laws.
Okay. Well, Ed Coburn, and I say that not just because Ed runs Renewed. I think this is actually an interesting concept, and maybe it's a concept that might form a new renewed member business. But he asked, is there? I mean, like with sales tax, there's software out there that can let you know. I mean, can actually process sales and appropriate sales tax, let you know where that sales tax has been paid and tally it up and boom, you don't have to keep manual track of it sale by sale. Is there anything comparable in the world of privacy where there is a software or even a publication out there that will let you know what's happening with developments in state and local privacy laws?
I mean, there are a lot of resources out there. A lot of them are specialized and aimed at attorneys. There are, like for instance, there are companies that, and I have been investigating one on behalf of a client inquiry recently. I mean, there are companies that will offer like terms of service. There are, they run the gamut from like, free website. Oh, we'll create terms of service for you, to more in-depth processes where more in-depth offerings where you put in detailed information about how you're actually using information, how much information you're using, information about your company, and they can create terms and conditions for you that are updated. At least they advertise that these are going to be updated. For instance, the California Consumer Privacy Act, if you're a covered business, requires you to update your privacy policy every 12 months. And as these various jurisdictions enact new laws that might have new requirements, these products advertise that they'll stay up to date. So that's something. I mean, and some of these products look like they're legitimate and very good products and offer a good service, but buyer beware. Do your research before accepting any of these.
Okay, great. Tama, you've put an interesting question into chat. Do you want to offer that question to Steve, or I could summarize whichever way you'd like to go?
Whichever way you'd like to go is fine with me, John.
Tama, have at it.
Okay.
People have heard enough of me this morning.
Hi, Steve. I will say also, by the way, that I had a call with Steve and his associate, whose name just went out of my head, sorry, a couple of months ago, and they were really helpful in helping me review the privacy policy as just being really great supporters of Renewed. So I just want to say that. So my question is this: part of what we have, it's information about shopping centers, and so we have the information on, say, the leasing people and marketing people and so forth, and their information is readily available on the website. So even if it's not being provided to us by the landlords themselves, as with our inquiries to them to update the information, it's right there. You can see, John Smith is the leasing agent for this particular shopping center, and we'll use that in our data set. So can we do that?
Yeah, I mean, that's a great question, because here the person is putting their own personal information out there, right? So a great lawyerly answer, which is yes with an if, or no with a but. Potentially, this still could be considered, personal information, because it is information that identifies or can reasonably be connected to the individual. It is personal information, even if it's personal information that they have already kind of put out there in the public. You may very well still fall under privacy law obligations when it comes to the use of that information.
Mm-hmm. So, that being said, so that means all of us, so many organizations in in the information business, whether it be in a database or whether it be in a, even an article where it, refers to somebody. So you're basically saying we are all sort of at risk every single time we're doing that, but that's the nature of what our business is. So it's sort of hard to not do that.
Yes, well, again, I mean, there are ways that, that you can satisfy your obligations under the law. You can still, use that information. You just have to, abide by the principles of the privacy laws that cover your jurisdiction, which generally involves openness, transparency, giving the allowing the individual to contact you, to request deletion of their data if that's if it falls under circumstances where they can request deletion of their data, you basic, as long as you're transparent and open and disclose and follow your privacy policy, you can still utilize that data in your business. But and it very well, in certain circumstances, if the information is out there publicly by the individual, then your privacy obligations will be mitigated. However, it still can be considered personal information, and that is the reality of the business. Is that something you have to be cognizant of? What personal information are we using? How are we getting it? And what are we doing with it?
Right.
So,
Okay.
Steve, you've done the job of putting together a wonderful privacy statement. You've made it transparent. It's easily understood. It's on your website. Does that cover you, or do you have to get individuals' affirmative acceptance that they've actually seen the privacy statement? Is that a must? Is it a nice thing to have, or does it matter at all?
Depending on whose private information you're processing and how you're doing with it, and what you're doing with it, there may be obligations to give the consumer the option to opt out of their use of that information. Under the US privacy laws, currently, there is an opt-out requirement for the processing of personal information for certain uses. So you have to have a mechanism in place that allows the consumer to contact you, say, whether it's clicking a banner on your website the first time they visit, or an email address and a phone number that they can contact, where they can say, hey, I don't want my information used for this purpose. Typically, targeted advertising, selling the personal data. Under the GDPR, for certain classes of information and certain uses of the information, there is an affirmative opt-in obligation. And I think, as I mentioned earlier, one of the state privacy laws that's making its way through the New York legislature does provide for an opt-in requirement for certain information. So you have to get affirmative acceptance from the individual. So in answer to your question, yes, under the GDPR, for certain uses of privacy, you have to get affirmative. For certain uses of private information, you have to get affirmative acceptance. Under US state privacy laws, for certain uses of personal information, you have to give the individual an option to opt out of it. And in the future, we may see state laws, US state laws, that require affirmative acceptance for the use or processing of certain personal information. So while you may be fine with a nice solid privacy policy that is clear, easy to understand, readily accessible, you may have obligations beyond that, depending on whose personal information you're collecting and what you're doing with it.
Okay, that's good, Steve. Thanks very much. I think folks that Steve has demonstrated today the reason lawyerly billings go up and up and up. It's a lot of yes with an ifs and no with the buts.
Yeah.
But frankly, I would rather hear the ifs and the buts and be completely informed about what all the potential worries are than to be left in ignorance or given false security through some sense of certainty. So Steve, I think we're coming up on an hour, and I'd like to thank you. Do you have a final word for us, or?
Well, to that end, John, and I appreciate it. And as we were putting together, this webinar, that was my concern. Is like every answer is going to be it depends, because it's the nature of this area of the law. It's relatively new. The GDPR is the oldest comprehensive privacy law that and that was enacted in 2018. So it's a developing area of law. It's a patchwork of these various jurisdictions. So it can be a jumble, and it's the nature of this area of the law that a lot of it depends. But to that end, as Tama, who asked a question earlier, took advantage of, our firm offers, a complimentary consultation. You can, after this, and there's the slide, you can give me a call. Me or one of my colleagues will be happy to sit down with you on the phone, ask a little bit more pointed questions about your specific use case, your specific organization, can give you a little bit more guided direction. And if there's issues that arise then you will have a little bit better idea of, from that personal conversation of the issues that, apply to you. So you can shoot me an email, you can give me a call. I'm happy to sit down, no charge, and talk to renewed members. It's something that we offer.
That's great, Steve. Thank you very much. And I would second Tama's remark that I found you to be, an excellent source of advice and very congenial fellow. Just don't go into the vicinity of Ohio State football with this guy.
Yeah, well, one day, Michigan will improve. What's the record for the past 15 years, John?
Steve, let's talk about what's the record for the last 2 years. But
Okay.
I don't think Ohio State, Michigan matters so much to the folks here today as your privacy advice does. Thank you very, very much, Steve. Folks, please do take Steve up on his willingness to talk to you offline. Thanks for your questions. Thanks for your time, and share it with other renewed members who may have missed today. Steve and his colleagues at Powley Gibson are very, very happy to help. They are solid supporters.
Thanks everyone for joining. Thank you again, Steve and John, for a great session. And
Thank you, everybody.
All right, take care. Bye-bye.
Bye-bye.